Hi everyone, welcome back to our podcast, Moving to Australia. I'm your co-host Arun Belur, and joining me in the studio today is our founder Amitava Deb. Today we're going to focus our discussion on the most frequently asked questions for the Australian PR process. We are going to be covering a range of topics like skilled migration, regional migration, employer nomination, because these are the most talked about topics when we have clients who come on board or when we have an hour-long skill assessment session with them over Zoom. Mm-hmm. So without further ado, let's dive right in. Amitava, how have you been? How's your weekend?
Yeah, very good. Thank you. Good afternoon. Very hot today. How is the weather in Gosford?
Oh, it's extremely hot. It's about 32 degrees. Unusual for spring.
Now, right?
Very, very unusual for spring at this time of the year.
Yes.
But I'm still loving it. Better than the cold weather.
Yes. Well, I like cold weather.
So let's dive right in. Let's start with skilled migration. Mm-hmm. The most frequently asked question when it comes to skilled migration at the very top of the list is, who should be the primary applicant? Should it be me or my spouse?
Yes. Many prospective migrants who are married or they have a partner, de facto partner, and they want to start the journey for Australian PR process. The first question they ask, okay, I am qualified, my wife is qualified. I think my wife has better skills. So should she be the primary applicant and me secondary? Or they don't even say secondary, they say dependent. So here is my answer. When you start, you don't know who is going to be primary. Who will be primary will depend on who is invited first. The strategy should always be both the applicants, if they have the required skills, should get their skills assessment done, do their English test, because that's the mandatory requirement, and then subsequently will lodge expression of interest, EOIs, for all the states that participate, in addition to the general category, which is subclass 189, and also additionally maybe ROI, registration of interest, for the states that participate in that registration of interest process. So after doing all these, floating all the EOIs/ROIs, one per person will get invited, either the primary or the secondary. Whichever person gets invited, I would say go forward. The rest of the family then becomes secondary applicant. It doesn't matter. Ultimately, the aim is to have PR. It can be through the main applicant. Well, there's no main applicant in that respect. Could be the husband, and or it could be the wife, and then the other people, other applicants can be secondary applicants. So one thing to remember, there is no such thing as dependent. A lot of people ask me, who is going to be dependent? There is no dependent. It's either primary or secondary. Primary, by its definition, one person can be primary, and everybody else means spouse and children, can be secondary. But once the visa is granted, everybody has the same visa. The visa does not say who was primary, who was secondary.
Yeah, even though the cost when it comes to skill assessment and taking the English test goes up, you would still make this recommendation because the probability of you now being invited significantly goes up, because now you have two of them putting in their application, lodging their EOI.
But it also depends on which occupation and what is the backlog for that occupation. Just to give an example, an accountant with a very, very high score could be way behind the queue because there are many accountants in the system waiting, may have a lesser chance than someone, say a florist, probably because there's hardly any florist in the queue.
That's why the skill assessment is so important when you guys do it.
Well, it's mandatory, important and mandatory. Without skills assessment, one cannot move.
All right, jumping on to the second question. If I am the primary applicant, can I include my spouse later?
Yeah, if you have a lot of money, yes, you can. If you include your spouse at the time of application, the primary applicant pays 4,000 something, and the spouse has to pay, or for the spouse, you have to pay 2,000 something. However, if you think that I want to add spouse later, so you get the PR, you want to add the spouse, it is 9,000 something dollars. So it's just plain arithmetic. You add the spouse. Maybe the spouse can join you later, but get the PR for the spouse as well.
Now, why would
Makes
somebody
sense?
even think about including
Think,
their spouse later in the
because they
application?
don't know. They think that if they include, they'll have to travel with the spouse, and it's very expensive. So what I keep saying is that you get the PR. It doesn't mean that everybody has to pack their bags and leave. Just one person goes there, finds a job, gets a decent settlement, and then gets the rest of the family.
Yeah, that's reasonable advice.
Mhm.
Number 3, I have 10 years of experience in IT. Why does Australian Computer Society deduct 2 years or more from my initial work experience?
That's a very interesting question. Earlier, there was no deduction. Now, deduction is actually uh, the real terminology is deemed. Someone is deemed skilled after certain years of experience. So, if you do not study in Australia, suppose you study in the UK or even in Russia, and if you study bachelor's degree in IT, then the initial 2 years of experience is considered required to attain the required level, which means those 2 years will not be counted towards your points. Those were removed. That is if you have studied IT. Now, if you have studied minor in IT, like electronics and telecommunication engineering, then there will be a deduction of 4 years. That means you will need to be working for 4 years before you are assumed to be skilled. And if you study non-IT, like say you did Bachelor of Commerce and MBA, then you need 6 years. And if you have not studied at all, then you need 8 years.
Because your experience is now nothing to do with your academic qualifications. They're completely separate.
Yes, well, correct. That's why the number of years required is more. And of course, to be reasonable, they say that you have studied civil engineering, and hence you probably needed 6 years of experience to be at the same level of someone who is qualified as a software engineer. A lot of people come to me and say, "Oh, I have studied civil engineering, but I haven't had a lot of IT courses." Still, if you do the mapping of subjects, they in the overall scope of subjects studied, those subjects would be negligible. The major is civil engineering, right?
Correct.
So that's how it is.
So this is something that you see only in the IT industry or any background
Other,
or other majors as well,
um,
like civil, architecture, mechanical, electrical.
not in engineering. Engineers Australia do not make any such assumption. You are an engineer based on your qualification, as long as your qualification is recognized. That's what Engineers Australia say. But there are other assessment bodies like VETSS. They will deduct, and they have a chart. If your occupation is in Group B, you're required to have a bachelor's degree. If your bachelor's degree is in the nominated occupation, then 1 year of experience is required before you attain the required level. If your education is not in the nominated occupation, then 3 years is required. So there's a whole lot of things. They will deduct certain number of years of experience, and that is all listed on their website. I'll give an example. Management consultants are assessed by VETSS. Now, if you have an MBA, then only 1 year of experience is required to attain that required level. Now, if you do not have MBA, suppose you have Bachelor of Information Technology, and then you have become a management consultant, then you need 3 years of experience.
The next one. Can I include the years that were deducted by skills assessment body towards my experience points?
There was a change in the regulations which suggested that you can indeed include the initial experience towards your points as long as it is aligned to NSCO. So even though Australian Computer Society removes 2 years, you can still claim. Having said that, the state governments do not accept that. The state government will say, no, no, we really want you to claim only the experience the skills assessment body has suggested, especially New South Wales. Some states do have a concession. I had a situation with South Australia, they accepted the years that were deducted. But generally, for sub plus 189, you in fact can claim that experience if it was after your qualification.
Moving on. This is probably on the top of the list of everybody. How long is my skill assessment valid for?
Skills assessment is usually valid for 3 years unless otherwise stated. Now,
Stated by the assessment body?
Yes, Australian Computer Society states it is valid for 2 years. Everything else is valid for 3 years. Now, Engineers Australia they have a different way of looking at it. They say that their skills assessment do not expire, but because the department will not accept skills assessment after 3 years, you can request them after 3 years. You can request them for a reissue of the skills assessment letter.
Is there a fee for that?
Yes, 100 something. It's very nominal fee, as against $1,000 something.
For the assessment by Engineers Australia.
They call it reissue of the skills assessment letter. However, if you have gained experience and you want experience assessment separately, then that's a different story. You have to pay for it.
Okay. But if I reach out to them and I request for this reissue, how long is that valid for then? Another 3 years?
Another 3 years.
How long is my English test valid for?
English test is valid for 3 years. Now, PT, it's a strange one because Pearson test in English, the test report will say our score is valid for 2 years, but the Department of Home Affairs will accept a score that is 3 years old.
And why is that?
That's how they have regulated.
Oh, that's good.
Mm.
Moving on to the next one. I have been invited for skill migration, but I am turning 45 next month. What will happen to my application now?
Once you're invited, everything is frozen. It doesn't matter if you turn 45.
So you just need to have the invitation before you turn 45.
Yes.
Okay, then let's connect this with a question that people have regarding regional migration. Mm-hmm. They say, I will turn 45 soon. Mm-hmm. How can I be eligible for PR after holding a 491 visa for 3 years, as I will be more than 45 years old when it's granted?
So for the purpose of the second stage, which is subclass 191, after holding 491 for 3 years, they do not look at your age. Your age has been screened when you are invited for 491. Subsequently, what matters is two things. You have lived and you have worked in a regional area for 3 years.
So the most important thing is to get into Australia before you turn 45.
Yes, well, not get invited. You can get into Australia.
Get into Australia, get invited.
Maybe your visa grant letter will come after 2 years. Well, it should not, but even if it does, you can still get into Australia.
So some more questions about regional migration. Now, a lot of people have questions about work opportunities there. So what do you have to tell them? Because they think that because there are less opportunities, they don't want to live in a regional area.
Yeah, well, I think work opportunities are probably proportionate to the population, right? Sydney, Melbourne, they are bigger cities, so more work opportunities. Regional areas like Adelaide, Perth, Canberra have lesser population, so lesser opportunities. But ultimately, it's the same situation. The competition will be even. Less jobs, less people looking for jobs.
True.
And another important thing is to remember is that regional area is not rural.
Yes.
So regional area, it's uh, the government as a policy, they want to spread out the population. I think newly arrived migrants, for psychological reasons, they would like to move to Sydney or Melbourne in the beginning. And then they will probably not move. So the government is encouraging people to move to other areas, saying, there is more to Australia than just Sydney and Melbourne. Just venture out, it's beautiful, there are opportunities. And when people move, opportunities are created.
That is very true. Can I move to another state after I get a subclass 491 visa?
The regulations do not stop you from moving to another state. Having said that, the state government usually they take a declaration undertaking saying, I am committed to this state for 3 years. So a state government may, if they want, may cancel your visa. They probably won't. But Home Affairs do not care because according to the regulations of 491, you need to be living in a regional area, meaning any regional area. It's just that you do not or you cannot live in Sydney, Melbourne, Brisbane. Apart from these three metropolis, everything is regional. It's like in India, um, Bombay and Delhi. Okay. So
Yeah.
a lot of people who want to move to India, they'll say, okay, I want to be in Mumbai or Delhi.
So
But
just
there's
to
more
clear
to
that
India.
out, so if someone gets a 491 from Adelaide and they move to Australia, they move to Adelaide, they don't get a job or they're not satisfied, they don't
Mhm.
have to continue living there. If they seek employment elsewhere in another regional area, it could be
Right.
Perth or it could be Tasmania,
Mhm.
Hobart, they can still move there and make a living.
Correct.
So moving to employer nomination.
Mhm.
I want to apply for a work permit. Can you help me? That's a
Um,
frequently asked question for you.
yes, yes. So I think a lot of people confuse with the H-1B visa of US. Okay, for Australia, if you want to apply for a work permit, you need to have an employer. A lot of people come to me asking for work permit, and I say, look, I do not issue employment. You need to find an employer. Once they have an employer who can sponsor, I can help with the process. It's a three-stage process.
Mm-hmm.
An employer has to be first approved to be a sponsor. Then they have to go through the nomination process, do the labor market testing, and then once the nomination is approved, the applicant can apply for the visa, the work permit visa. It's also known as TSS, Temporary Skills Shortage Visa.
Does this take longer than what it would normally take for a 189 or a
No,
491?
this is processed very fast,
Very
within a
fast.
couple of months.
Okay, but you have to find an employer who's willing to
Mm,
employ you and sponsor your visa.
yes, correct.
And that will further on just lead to pathway to permanent residency.
A lot of Indian IT companies, they get specialists for short periods of time on this visa, like TCS, Tech Mahindra, Accenture, they all utilize this visa.
Coming to partner visa,
Mhm.
a lot of people have questions around how, as a citizen or as a PR holder, they can bring their partner into Australia.
Mhm.
So one of the questions is, if my marriage was arranged, which happens in some cultures, how can I prove history of relationship for partner visa?
The government is aware of arranged marriage situations and that there may not be a history of relationship, then these situations need to be covered using statutory declaration. So they have to narrate how they have met. It could be through matrimonial websites. It could be through introductions from the respective parents and how they met each other. So there needs to be certain element of connection. It cannot be like you arranged and then the guy comes there to India or wherever and gets married without having met. So it is important to meet, know each other, and that knowing each other could be just for a day, and that's fine. You can't get married without meeting a person first.
How does the government define history of relationship? If someone is not married, if it's their de facto partner and they've been in a relationship for 5 years or longer, then how does one prove the history of relationship? What is it that they are looking for?
Relationship, if someone is not married, then they need to be living together for 1 year at least. They have to demonstrate that they have been living for 1 year immediately before the application. And usually that is through joint lease and joint ownership of assets and liabilities. So maybe they took out a home loan together, so that's a joint liability. They took a joint lease together, bought a car together, traveled together, and you need to have photos together and describe those photos, not just both together, but with families and friends to show that the relationship is recognized in the society.
Okay. Moving over to business visa.
Mhm.
One of the questions that you get asked quite often is, how much money do I need to invest for a business visa?
Lots of money. Sorry. Uh, that's where I think people go wrong. Business visa doesn't mean you have lots of money and you come and invest. You need to have a history of either business or investment. So there is a visa category known as subclass 188 business innovation. In that visa, there are 4 or 5 streams. The first one is business innovation. That means someone has been running a business for at least 2 years. They were at least 30% owner. The turnover was more than 750,000 Australian dollars. They have assets of more than 1.25 million Australian dollars. Then they're eligible to apply.
Okay.
Okay.
That's
So
a big investment.
that's the business innovation. Business investment visa is when someone maintains a portfolio of investments, like someone who invests in share market, for example, and they have invested at least 1.5 million Australian dollars in any one financial year in the last 4 years. Sorry, last 5 years. Then they are eligible to invest. So investor visa is $2.5 million. Now, there is a catch. They can only invest in government bonds, state government bonds.
Okay.
They cannot invest in buying a property, for example. How does Australia gain if someone brings a lot of money and buys a house for himself and retire? So the purpose of business visa is to attract investors to come here, set up business, and contribute to the economy. not um, retirees who want to come here with a lot of money and just retire.
Another question for business visa is, my family is very rich, but I do not own any assets. Can I apply for a business visa?
One of the streams of business innovation visa is known as significant investor visa, SIV. So if you have a spare 5 million Australian dollars, then you can apply if you are invited by a state government, and that 5 million Australian dollars have to be invested in designated bonds, government bonds, and they'll be stuck there for 4 years. And then you have to have a business plan on what you intend to do once you get that money back. So all these rich people, they might have their parents give them a change of, $5 million. Okay, my son, go and build your life in Australia. They can do it that way. Or they can come here, set up a business, and their business can actually sponsor them. So if you are capable, you can set up a business becomes an entity, and that business as an entity can employ myself. It's called self-sponsored visa. I have done it for a couple of people, high net worth individuals.
Okay. And the last one for today. This is regarding people who are coming in as refugees from countries like Afghanistan, Syria, or Ukraine. And they ask you, can you help me with a refugee visa?
Oh, that's a humanitarian visa. There are several ways to apply. One cannot apply just from overseas. They have to be here. They have to have relatives here. It's a big gray area for me. So, and not anyone can just apply and move here. They need to fulfill a lot of rules. Now, a lot of refugee visas one can apply for once they are in Australia. But the reality is, how are they going to be in Australia in the first place? In those days, people used to come here on a boat. They somehow went to Indonesia, hired a boat, came to Australia. They're known as boat people. They came and said, we do not belong anywhere. Please help us, refugees. So I don't deal in those cases, but it's not easy. But there are genuine refugees, of course. And Geneva Convention lays out the requirements and how refugees can apply for refuge for a particular country. Now, if someone is traveling, say, to Australia via India, and they have spent 3 days in India, then the convention says that they should have applied for refugee status in India. They cannot then apply for refugee status in another third country. In fact, if they are genuine refugees, they lived in India for 5 days and came to Australia, they are not eligible to apply anymore. So it's a big area. Maybe we can talk about this Geneva Convention another day.
Sure. And on that note, I would like to say thank you. This conversation has been very, very insightful.
Thank you.
For those of you listening, thank you for your time and your patience. If you need to get in touch with Amitava, the links to the DMS website, his LinkedIn profile, and our Facebook and Instagram page will be in the podcast description. Thank you for listening, everyone. Goodbye. See you next week.